Today is Tuesday, May 17, 2022. It's about 7 minutes after 12 in the afternoon here on the East Coast. Last night, a California Superior Court judge sitting in Los Angeles struck down a law requiring that all corporations which have their headquarters in the state of California have 2 or 3 female members on their board, depending upon the size of the board. The same court, but a different judge, had already struck down a similar California law saying that all corporations headquartered in California have ethnic diversity on their board, defined in various ways, depending upon the size of the board. I mean, a board can be from one person, which is almost unheard of, to 40 or 50 people, which is also almost unheard of. But there's really no magic to the number. But both of these strike downs were based on the California Constitution. That's very interesting because that insulates this from federal review. Because under basic principles of constitutional law, the state courts of a state are superior to the federal courts sitting in that state when it comes to interpreting the state constitution. So if these two strike downs for ethnic diversity and gender diversity on corporate boards for corporations headquartered in California, some of the biggest corporations in the world, particularly the high-tech corporations, are headquartered in California. If this is upheld by the Supreme Court of California, theoretically, there's no appeal to the U.S. Supreme Court because the U.S. Supreme Court has ruled that state Supreme Courts have the final say on the meaning of state constitutions. Now, what clause in the state constitution did these judges rely on? Same clause that's in the federal constitution, equal protection. The equal protection clause, which requires that similar persons and similar entities be treated similarly, prevents the state from forcing a private entity to make a decision based on race or gender. Man, how long are we going to wrestle with these issues? Race and gender, race and gender, race and gender. Been with us for a long time as the courts struggle for freedom and the legislatures struggle for equality, and private industry is wasting all this money on legal fees. But right now, private industry has won. This is at the trial level in California. It can go to the intermediate California appellate court and then to the California Supreme Court, where it will probably end. Who knows how? Judge Napolitano for Judging Freedom.